Good afternoon, everyone. We're going to go ahead and get this is the state expedited accusations calendar in the state court of Fulton County, Georgia. I am Judge Melanie Williams, and at this calendar today, we will address cases for those individuals who've been recently arrested, or the cases have already been formally accused and bound over to state court. All defendants, please pay attention. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. As you can see, I am conducting this hearing over the internet as a live stream. It's also being recorded. That means any member of the public can log on and watch. When I ask you if you understand your rights, that's what I am referring to. Those who receive a signature bond will be reset further notice. Those who receive a surety or cash bond will be going to our state all-purpose calendar on March the 20th, whereby certain aspects of the case, including bond or contact provisions, can be revisited. Have all defense attorneys had the opportunity to interview their clients?
Your Honor, there is a Daryl Wimbush, Wimbush, who I believe is at Grady, and I don't know if there are going to be any arrangements or possibilities for seeing him today.
Any announcement in courtroom two? Is that party there, or is number 11 a medical reset?
Your Honor, he is at Grady, but the sergeant, I believe, gave Mr. McLean Grady's number to speak with him. I'm not sure if
Nope.
he a medical reset.
No, but I'd be glad to receive such a number.
Okay, so Mr. McLean, if somebody could chat Mr. McLean the number to try.
Okay.
All right, everyone else?
Good afternoon, Your Honor. I have a client at the South Annex, Mr. Cloud. I have not been able to interview him. When I called, I was told that they were having some kind of shortage of staff, so they would call me back. But as of now, I haven't heard back yet.
Any announcement on Mr. Cloud, position 1?
Your Honor.
Okay.
We'll try
Hopefully. I'm sorry, say that again. My apologies.
We'll try to get in touch with South Annex.
Okay, thank you. They're gonna try, Ms. McCloud. Anyone else?
Thank you.
All right, let's forge ahead. Who do we have first?
Judge, your reset date is
March 20th.
3rd.
I said it. Thank you, Ms. Lewis.
You're welcome.
It's in the chat too, right? So everyone who, again, our reset date is the 20th for those who receive surety or cash. All right, who do we have first?
This is number 3, Ms. Goldbarn.
All right, Ms. Goldberg, your case is 25 CR 001174J. In this case, you are charged with criminal trespass. Do you understand your rights today? Is that a yes? I'm assuming that's a yes. Mr. Howard?
Yes.
I'm sorry,
Yes.
say that again?
I'm sorry, Your Honor, Mr. Sheriff, tell everybody to speak up so they can hear you.
Thank you. I appreciate that. Yes, speak as loudly as you can so we can hear. All right, go ahead, Mr. Howard.
Here's the rest. Got an open harassment phone call out of Gwinnett as of September of last year. Open case in Fulton, possession of a sawed-off shotgun, a rifle, or machine gun. Unlawful carrying of a weapon, shoplifting, possession of a knife or a firearm during the commission. It's 25 SC 000201. 2023 trespass, 2 counts conviction.
Okay, thank you. Ms. Tucker, please proceed.
Good afternoon, Judge. We'd be asking for a $1,000 good bond in this case with conditions to stay away from the Days Inn Hotel at 2451 Old National Parkway in College Park. These facts allege that this defendant barged into the back room in a hotel where only staff are allowed. She got into a physical altercation with another female and was demanding the hotel staff to show footage of this incident on their security footage. The witness, Ashutosh Rajput, declined to show her the footage, so she punched and destroyed that TV that they watched the security footage on for the whole hotel. But I do not believe this is a good candidate for a signature bond. You did hear that history. This is the 5th arrest just in the past 3 years. Harassing phone calls. You heard possession of sawed-off rifles, theft of service, and an aggravated assault in 2023. That was null prost. But based on the history, recent history, as well as the facts, I believe a $1,000 good bond is appropriate with that stay away condition.
Thank you, Ms. Tucker. Who represents this defendant?
Your Honor, before Mr. Shatai goes, I was just told that her bond was posted,
Oh, okay.
Oh, she made bond. What was her bond?
1,000 surety.
Oh, and she's already made it, so I guess that's what it'll be. But we are gonna add Miss Lewis, I'm still gonna do the order and add those stay away conditions.
Thank you, Judge.
All right. Best of luck to you, ma'am. Who do we have next?
Position number 7, Mr. Nance.
Oh, that's hard.
All right, Mr. Nance, your case is 25 CR 001178D. In this case, you are charged with simple battery. Do you understand your rights?
No,
You have a right to remain silent. You have a right to an attorney. You understand that?
I don't understand it, but they go.
Okay. Will you we've informed you of your rights, so we're gonna forge ahead. Mr. Howard?
5th arrest. Got to open possession of a Schedule 1 or 2 controlled substance with intent out of Clayton County. Open up obstruction out of Griffin and shoplifting out of Atlanta. 2022 trespass no-low. I think he's homeless. That's it.
Okay. All right. Ms. Allen, please proceed.
Thank you, Your Honor. Good afternoon. This
Good
is an
afternoon.
incident from March the 3rd. The defendant was arrested at 1056 DeKalb Avenue Northeast. That was after he threw a warm, sticky liquid on the person of a bus driver, Corey Pugh, while on the bus at the intersection of Lancaster and Shannon Parkway in Union City. The victim reported that a gentleman, and he gave the defendant's description, boarded the bus and asked to ride. When the bus driver told him he needed to pay the fare, the defendant became angry and threw a warm, sticky liquid on his person. Surveillance video
Oh,
showed this assault.
no.
You just heard that the defendant has 3 open cases, including a felony drug case out of Clayton County. We would ask for a $2,000 surety to stay away from the MARTA bus, and specifically that operator, Mr. Pugh, P-O-U-G-H. No drugs, alcohol, or weapons, and we'd ask for a social worker visit, Your Honor.
Right. Is Mr. Pugh on this line conference and wishes to make a statement?
I don't believe so.
Sounding just in case. All right. Who represents this defendant?
I do, Your Honor.
All right, please proceed. Good afternoon.
Good afternoon, Your Honor. My client, I would ask the court to consider the possibility of a signature bond, if not the lowest surety amount possible. My client is 27 years old. He is a lifelong resident of Georgia. He lives in Atlanta. In terms of schooling, he has 1 year of college under him. He studied IT at a community college in Georgia, I believe, Georgia Military School, although he doesn't have military service. And most recently, he worked at a Ruby Tuesdays. He worked there for a couple of years. With those factors in mind, I'd ask the court to consider the possibility of a signature bond, and I would not object to a social worker visit.
Thank you. Thank you.
Okay. All right. Defendant's going to receive a $1,000 surety bond. He is to have no contact with the alleged victim in this case. I'm not going to ban him entirely from MARTA at this time. Not sure, but if MARTA has banned him, he needs to abide by that. And additionally, he's had no alcohol, drugs, weapons. I am going to ask for a social worker to make a visit. All right. Is there anything additional from state or defense? Okay. Best of luck to that gentleman. Who do we have next?
Position number 4, Mr. Hill.
All right, Mr. Hill, good afternoon. Your case is 25 CR 001175E. You're charged with giving false information. Do you understand your rights?
Yes.
All right. Mr. Howard,
18, last was 2022, possession of a firearm by a convicted felon or felony first offender, suspended license. That arrests, those charges were dismissed. 2018, theft by deception conviction. 2014, 2015, probation. His history is full of theft and suspended license.
okay. Thank you. Ms. Tucker?
Yes, Judge, the state would be asking for a $1,000 good bond with a condition to stay away from 1700 Ridgefield Drive in Roswell. These facts allege that officers were dispatched to this location over a dispute over pine straw. The victim never agreed to a price prior to the pine straw being laid out, and after the project was done, this defendant said it would be $3,200 and refused to leave until he got paid. While he was speaking with the officer, he claimed to be Earl Terry and that his birthday was 4/10/1987. Stated that his business was Earl's Pine Straw and that he had a permit but couldn't remember the number. They were able to identify him by his phone number. It came back for Jason Haley. They Venmoed Jason Haley to pay for the pine straw, and he had been investigated by Roswell PD before for this exact situation. You did hear a recent 2018 theft by deception conviction. He's got a 2014 theft by deception conviction, a prior theft by deception arrest. So I believe, considering the history as well as, even the officer, recognized that he had been previously investigated before, I believe the risk of reoffense is high. So I do not believe a signature bond is appropriate. We're asking for that $1,000 good bond with condition to stay away.
Okay. All right. I had a question, but it's escaped me. All right. Who represents this defendant? Is it Mr. McLean?
This is my client, Your Honor.
Okay, please proceed.
Yes, Your Honor. My client is 35. He is a lifelong resident of Georgia. He has 2 years of college under him. He went to Gordon State, and there he studied computer science, though he wasn't able to obtain his degree. And he's currently self-employed. He has a landscaping business, and he mostly cuts grass. For those reasons, Your Honor, I ask the court to consider a signature bond. Otherwise, we would like to ask for the lowest surety amount possible that would secure his return.
Okay, give me 1 second. All right, defendant is going to receive $1,000 surety bond, and he is to stay away from that location, have no alcohol, drugs, or weapons. And as a reminder, he's going to the all-purpose on the 20th. Best of luck to you, sir. That concludes your case. Who do we have next?
Good afternoon, Judge.
Good afternoon.
I have position. Oh, if you can read the ladies their rights, please, Judge. Thank you.
All right, and who's sitting in the chair?
It's going to be position number 5, Ms. Jenkins.
Okay, I was making sure it wasn't that one add-ons. All right, all defendants at the ACDC, please pay attention. I'm Judge Melanie Williams. This is the State Expedited Accusations calendar. At this calendar today, you have certain rights. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have a right to an attorney today. When I ask if you understand your rights, that is what I am referring to. As you can also see, I am conducting this hearing by video. All right, Ms. Jenkins, your case is 25 CR 001176E. You're charged with simple assault and disorderly conduct. How do you understand your rights today? All right, thank you, Mr. Howard.
10th arrest, 2018 battery DV conviction, 2009 given false name.
Okay, thank you. Ms. Tucker.
Yes, Judge. On the simple assault, we're asking for a $1,000 good bond. On that disorderly conduct, a $1,000 signature bond. For a split bond, with conditions no further contact with Shantavia Ellis, and to stay away from all MARTA. If not all MARTA, then at least the Hamilton Homes MARTA station where this occurred. The victim, who is a MARTA bus driver, asked the defendant to get off after disrespectful comments about him loading his money into, her loading his money into the fare box. This defendant refused to get off, began yelling and cursing at her until she herself decided to get off the bus. And as she was leaving and talking to her supervisor, he attempted to kick her while her back was turned. This incident is on the MARTA bus security footage and confirmed the allegations by the victim. We did attempt to call the victim. We were unable to get in contact with her if we could sound for Miss Ellis. But based on the violent history, the battery, family violence conviction, we're asking for that split bond with conditions no further contact and to stay away.
Okay. I'm sounding for Miss Ellis. All right, hearing none. Please pronounce your last name for me so I get it correct.
My last name is Chitaya.
All right, Mr. Shataya, please proceed.
Yes, Your Honor. My client is 43 years old. She is a minimal flight risk. She has been a lifelong resident of Georgia. She lives in Atlanta. She has a high school diploma, and she's done 2 years of college at Atlanta Area Tech in early travel and development. She currently does not have a job. She takes care of her 2 children. They are 9 and 5 years old, and she is their only parent. Their father is deceased. Most recently, she worked at a warehouse for a company called PCA, I believe. She worked there packing things, and she did that for about 3 years. We would ask the court to consider a signature bond in its entirety, Your Honor, for this case. And I would also object to staying away from all MARTA stations. My client informs me that she relies on MARTA stations to get her children to and from school. So if there is going to be a restriction on the use of MARTA, we would ask it to be minimal.
All right. Defendant's going to receive a $1,500 split bond. It's going to be $1,000 surety on the simple assault and $500 through the jail on count 2. She's to have no contact with Miss Ellis. I am not going to restrict her from MARTA at this time. However, if MARTA has their own restrictions, she must abide by those. She's to have no alcohol, no drugs, no weapons as a condition. And because of the split bond, she is going to all-purpose as well on the 20th. Is there anything additional? All right, hearing none. Best of luck to you, ma'am. Take care. Have a good day.
Can you repeat that bond again? I'm sorry.
15 split, 1,000 surety, count 1, 500 to the jail, count 2.
Okay, thank you.
Condition number 6, McFarland.
All right, Mrs. McFarland, your case is 25 CR 001177J. In this case, you're charged with battery family violence. You understand your rights? Is that a yes?
Yes.
All right, Mr. Howard.
Second arrest, 2023 assault 3rd degree, dismissed.
Okay, 2023. All right, Ms. Tucker.
Yes, Judge. Considering the lack of history and we've spoken with this victim, the state is asking for a $2,500 signature bond, but with conditions no further violent contact with Quincy Mitchell. The facts allege that a dispute with the victim who lived with her at this incident, the defendant was playing music loudly, not allowing this victim to sleep. She started getting aggressive. When this victim got up to turn off the music, this defendant threw a boiling cup of ramen noodles on him, burning his skin. There was visible redness and burns, and the skin was even beginning to peel on his stomach by the time the officers came. We were able to speak with this victim. He confirmed that they are in a relationship. They no longer live together at this incident location, and they share no children. He did confirm the events in the warrant, stated this is the first time this has happened, but after this, she moved out. He stated he's not in fear of her, but he is on the Zoom today, so I will let him elaborate. But for these reasons, we're asking for that $2,500 signature bond with conditions no further violent contact.
All right, Mr. Mitchell, if you're on the Zoom conference, please raise your right hand and unmute your screen if you wish to make a statement. However, you are not required to do so. All right, please raise your right hand. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and given under the penalty of perjury?
Yes, Your Honor.
All right, you can put your hand down. What I'm most concerned with today are any concerns you have for your safety and your desires for contact with the defendant. What would you like to tell me today?
Yes, Your Honor. Like the previous lady said, I don't fear for my life from her. We're still in a relationship. I still love her. I still want to be in contact with her. I just think night the incident happened, there was just a lot going on in both. With all that in a studio apartment that's already small, we were just eventually going to end up clashing. Regarding the hot water, the noodles, she only did that because she felt threatened by me. I was invading her space. She did that to like press charges. I never intended for all this to happen, but yeah, I still want to be with her. And me being the boyfriend, I would be able to. I wouldn't be able to pay that high of a bail bond, but I'll be able to do whatever I can handle.
Okay. Thank you, Mr. Mitchell. I appreciate you making that statement and coming to court today. Mr. Shataya, is this your case or is this yours, Mr. McLean?
This is my case, Your Honor, and I don't object to the state's recommendations.
Okay. You may want to tell me about her because I'm not sure that's what I'm going with.
All right.
Would you like to tell me about your client?
Yes, Your Honor, I will. My client is a lifelong resident of Georgia. She presents, therefore, minimal flight risk. As we also heard from pre-trial, she has a very limited history. This is just her second offense. She's 22. She is currently a junior in college. She goes to Georgia State and she's studying political science. She's supposed to be starting a new job on Monday. I believe that job has to do with childcare. And as we just heard from the complaining witness, he's not afraid of her. My understanding is that they're living separately, and right, for those reasons, I asked the court to consider following the state's recommendation.
All right. Defendant is going to receive a $4,000 signature bond through pretrial services at level 1. I'm sorry, at level 2. She's going to take a 2-day anger awareness course and have no further violent contact with the alleged victim. Additionally, she's to have no alcohol, drugs, or weapons. As I'm allowing her to sign her own bond, she will be reset for the notice. Is there anything additional from state or defense?
Nothing further.
Nothing further.
All right. Best of luck to you, ma'am. That concludes your case. Who do we have next?
Jonathan, can you repeat that bond amount?
4,000 SOB pretrial level 2.
We could go to position number 8, Mr. Ori.
All right, Mr. Ori, your case. Sorry, what number? I'm on the wrong one. All right, here we are. Your case is 25 CR 001179H. In this case, you're charged with criminal trespass. You understand your rights?
Yeah.
All right, Mr. Howard.
2017 retail theft conviction, 2016 trespass conviction, 2012 and 11 probation, 2010 forgery in the first degree conviction.
All right, Ms. Allen.
Thank you, Your Honor. This is a criminal trespass, specifically from March the 6th at 370 Northside Drive. That's the Wesley on the Beltline residences. And specifically, we're talking about unit 1011. At about 11:16 a.m., the defendant was located inside that unit. He was spoken to by police as well as security and maintenance. He acknowledged that he was not supposed to be at the location and had been previously criminally trespassed on January the 30th of 2025, when he was also found in that unit and identified. He said he was there in the vacant unit because he was cold. And so when he returned on March the 6th, he was arrested. He's listed as residentially challenged in the documentation. We'd ask for $1,000 surety, Your Honor, to stay away from that location, have no drugs, alcohol, or weapons, and we'd ask for a social worker visit. Thank you.
All right, I'm sorry, and 370 Northside Drive is what, Miss Allen?
It's the Wesley on the Beltline, Westley.
Okay, we don't know what that is. I'm gonna look it up. All right.
It's residences, it's apartments.
Just apartments. Okay, just making sure. All right, Mr. Shishaya, please proceed, or is this Mr. McLean?
This will be mine, Your Honor. Thank you. Mr. Troy Oree is from Georgia for the last 6 years. He's 60 years old. He's 12th grade. Well, he's a high school graduate. And Your Honor, he's worked in a restaurant for the last 2 or 3 years at a different restaurant for 7 years before that. So he probably does need some advice from our social workers about how to get better housing. We'd ask the court to consider this signature bond.
All right. Defendant is also going to receive $1,000 surety bond. He's to stay away from that location. I am going to ask that the social worker visit him. Additionally, he needs to have no alcohol, no drugs, no weapons. Is there anything additional? All right. Best of luck to you, Mr. Oree. Who do we have next?
This is gonna be position number 2, Ms. Crandell.
Okay. Ms. Crandall, your case is 25 CR 001173A. You're charged with obstruction and criminal trespass. Do you understand your rights? All right, Mr. Howard.
10th adult arrest. Got an open shoplifting 24 PI 003 250 2024 FTA 2023 FTA 2019 FTA 2018 battery Nolo.
Okay, thank you. Whose case is this for the state?
I can handle it, Your Honor.
All right, please proceed, Ms. Allen. Thank you.
Thank you. This is an incident from February the 28th at 1000 Holcomb Bridge Road. The defendant in front of you was approached because she was walking her dog off of a leash. Officers noted that her co-defendant, the individual with her, last name Galvin, had an active warrant. The individuals reported they'd been coming from the Tahoes, which is now Roswell Creek Apartments. This is an area that's regularly broken into and where squatting is an issue. The young woman with him was the defendant in front of you, and she was identified and noted to have been previously trespassed from the locations. She had wires, copper wires on her, and she reported that they'd been found in the dumpster. You just heard that there had been multiple failure to appears, an open shoplifting case. We're asking for a $1,000 good bond, no further contact with Mr. Galvin, who's her co-defendant, no drugs, alcohol, or weapons, and we'd request a social worker visit.
Okay. All right, Mr. McLean?
That's actually,
That'll be somebody.
Cloud's case.
Oh, Ms. McLeod? Is Ms. McLeod? Is she on the phone?
It doesn't look like it, Judge. Might just have to come back.
I mean, if she's speaking to somebody else, Ms. McLeod is here.
Oh,
She's not speaking to no one.
Ms. McLeod, are you there?
we can come back to her case, Judge.
Oh, no. Okay. All right, who do we have next? Well, we're coming back to you. Please hold. Oh, Ms. McLeod, there you are. Did you hear Ms. Crandall?
Yes, Your Honor, I'm here.
Are you ready? Did you hear Ms. Allen's position regarding Ms. Crandall?
Yes, I'm ready to do Ms. Crandall.
All right, please proceed. We're ready for you, Ms. McLeod. Ms. Allen's already presented. That's what I was
Yes,
asking.
I did not hear what she said for some reason.
Oh, that's what I was asking. Ms. Allen, will you summarize briefly?
Sure. This young woman was encountered on the 28th of February at 1000 Holcomb Bridge Road. She'd been previously criminally trespassed from the Tahoes or the Roswell Creek Apartments there. She was identified with her co-defendant, Moises Galvin. She had in her possession copper wire. which she said she had found in the dumpsters nearby. She's got an open shoplifting case, prior convictions for theft, and multiple failure to appears from this year. We are asking for $1,000 good bond to stay away from that location, have no further contact with her co-defendant, no drugs, alcohol, or weapons, and we'd ask for a social worker visit.
Ms. McCall?
We are okay with the social worker visit, Your Honor. My client is not in a position to pay for bond. She has not worked, she tells me, and has not been able to work for more than 2 years. So she is barely getting by. So any other bond other than a signature bond is not going to allow her to get out of jail. So based on that, I would ask the court to consider giving her a signature bond so she can get out of jail. Nothing further, Your Honor.
All right, defendant is going to receive $1,000 surety bond. She's to stay away from that location, have no contact with the cross defendant, have no alcohol, drugs, weapons, and she will be, I'm going to ask the social worker to visit her as well. She'll be reset to all purpose on the 20th, whereby aspects of the case can be revisited.
Thank you, Your Honor.
What's the breakdown, Judge?
Yes, it's 500 on each count.
So
All right.
surety, total surety?
Yes.
Okay, thank you.
All right, who do we have next?
Position number 9, Mr. Prosper.
Okay. Pulling it up. All right, Mr. Prosper, your case. Oh, there you are. 25 CR 001180Y. You're charged with DUI, reckless driving, driving while license suspended, and giving false information. Do you understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
34. 2024 DUI dismissed. 2021 probation and FTA. 2 FTAs from 2018, 1 from 17. Well, 2 from 17. 2010, 2006 DUI conviction. And he had 2 DUI convictions from the 80s.
Okay. All right, Ms. Allen.
Thank you, Your Honor. First off, we're asking for a $10,000 surety on this case. No drugs, alcohol, or weapons. No driving without the proper license and registration. No contact with the victims in this case specifically. Their names are Patrick Anderson and Bianca Lee. It's unfortunate that the warrants came in written the way that they were. When I pulled the police report and reviewed it, this is a very serious injury by vehicle, and it should be transferred as an upgrade. That's something we'll be pursuing. This is a DUI accident and collision from November the 24th of 2024. At about 3 a.m., officers responded to an accident where the individuals in the vehicle this defendant struck while he was intoxicated were trapped inside the vehicle. The fire department had to come and free them, and both of them sustained serious injuries and were transported to Grady. The defendant in front of you gave false information. He reported that his name was Michael Prosper, which is convenient because he does actually have a twin brother. And Michael Prosper, the twin brother, was later arrested. This defendant in front of you was properly identified in January of 2025, and that's what the false information is. But ultimately, that should also be a felony, Your Honor. He is charged with reckless conduct today for driving while intoxicated. He admitted that he had had several mixed drinks at a nightclub before he drove. It is also alleged that he went through a red light, and that's when he caused this collision, injuring these 2 individuals. His driver's license had been suspended in May of 2024. So in front of you today, you've got a DUI less safe based on the admissions, the reckless for driving while intoxicated, driving on a suspended license, and providing false information. However, there will be additional charges on this case. We have not been able to reach the individuals who he injured or his brother, who is arguably also a victim in this case. When he was properly identified as Mark Prosper, warrants were obtained, and that was on February the 22nd. And here he is before you today. You just heard he's got multiple DUI convictions, and there's clearly an issue here. So we're asking for that $10,000 surety, Your Honor. And again, no drugs, alcohol, or weapons, and no contact with the victims, Patrick Anderson and Bianca Lee. Thank you.
Okay. Mr. McLean?
Thank you, Your Honor. Mark Prosper lives on Woodbury Place in 30034, excuse me. So I believe that would be Decatur. Yes, it is Decatur. Your Honor, he has gone through college through the sophomore year. He works at Amazon for the last year and does packaging and has worked in that sort of logistics operation for his career. We would ask the court to consider the lowest bond possible. In this situation, a $2,000 or $1,000 surety bond. If not, I understand the court normally doesn't give a signature bond in DUI cases. But if it were possible, I would be asking for that. But we would ask for as low a bond as possible. He has got a stable address and will appear in court. Thank you.
All right, thank you. Defendant is going to receive a $5,000 surety bond broken down as follows: 2,000 count one and 1,000 on each remaining count. He's not to drive unless he has a valid license issued by the state of Georgia or other state entity. He is to have no contact with either of the alleged victims, have no alcohol, no drugs, no weapons as a condition, and he is also going to the all-purpose calendar on the 20th. Is there anything additional?
Somebody put
Nothing,
the
Your Honor.
chat
Thank
in-
you.
I'm sorry, can somebody put the chat of the victim names in the chat, please? I didn't catch the names.
I can do that, absolutely. Thank you.
All right, who do we have next? Best of luck to you, Mr. Prosper.
This is an add-on, position number 2, Ms. Ward.
Okay, give me 1 second. Uh-oh. Thought I was ready. Okay. Ms. Ward, your case is 25 CR 001183F. You're charged with obstruction, trespass, and public drunkenness. You understand your rights today? All right, thank you, Mr. Howard.
Ain't the rest. Got open reckless conduct, obstruction out of state court. You want the case numbers?
I have them in the email, if anyone else needs them. Go ahead.
Open case out of the cab, 2 counts of obstruction, possession of a firearm during the commission of a felony, possession of a Schedule 1, and reckless conduct. Another open case in the cab for shoplifting. Another one in the cab for obstruction, simple battery, disorderly conduct. 2024 shoplifting conviction. 2024 false personation. That was another state. 2024 giving false name conviction.
All right, thank you, Ms. Allen.
Thank you, Your Honor. The defendant in front of you does have an open case out of state court and is on bond from 2023. That bond requires her to have no drugs, alcohol, or weapons. The police documents note that she was in possession of a firearm when she was arrested on this incident, Your Honor. She also has what you just heard from pretrial, an open felony drug and possession of a firearm case out of DeKalb County. 2 open cases actually out of DeKalb County. Police responded to 2757 Main Street in East Point. That's the public library there at about 8 a.m. on the 4th of March. Police met with the administrator as well as security at the location, who reported that the defendant in front of you was in the children's section actively drinking out of a clear cup and refused to leave. She'd been asked to leave multiple times by the staff and security there and refused. Officers made contact with her. There was a clear cup from McDonald's next to her. She had a bottle of Hennessy on her person as well as that firearm. When officers asked her information, she was verbally disrespectful. She told police she had no name. She refused to identify herself and kept ignoring officers. Her speech was noted to be slurred. And she was, again, actively drinking there in the children's section at the library. She was detained and she refused to put her hand behind her back. She tensed her body to prevent from being cuffed and just was in general non-compliant and refused to follow verbal commands. We're asking for a $3,000 surety, Your Honor, to stay away from the public library in East Point. No drugs, alcohol, or weapons. There's a safety concern, not just for this defendant, but for the public as well. This is now the 3rd time she's been arrested just in this year for obstruction and being in possession of a firearm. And she's got 2 open cases in addition to the one that you just heard about here in Fulton County. And I'm sure just like our bond requires her to not have access to weapons, so she's in violation of it, that the bonds out of DeKalb County include the same. Thank you.
All right, thank you. Mr. McLean?
Thank you, Your Honor. Kyla Ward is 28 years old. She's been in Georgia over a decade. She has a child who was born here. He is in school. She will be starting Atlanta Tech soon to start her next course of study. She works in a warehouse and has also done housekeeping work. She has a stable address at Cato Marick, 30354. And so we would ask so there shouldn't be any problem in making court. We would ask the court to consider as low a bond as possible if it is a surety bond, and if it is possible, we would like to ask the court to consider a signature bond. But if it's a surety bond, we would ask, could it be 1,000?
All right, there are 3 counts. Defendant is going to receive a $1,500 surety bond, $500 on each count. She's to stay away from the public library and have no alcohol, no drugs, no weapons as a condition. Because it's surety, she is going to all purpose on the 20th. Is there anything additional?
Nothing.
All right, best of luck to you. That concludes your case, Ms. Ward. Who do we have next?
Position number 1 on the add-on, Mr. Terry.
All right, Mr. Terry, your case is 25 CR 001184E. You're charged with battery, family violence, simple battery, family violence, cruelty to children in the third, and simple assault, family violence. You understand your rights?
Yes, ma'am.
All right, thank you. Mr. Howard?
2018 obstruction conviction, 2018 shoplifting conviction, 2017 grand theft conviction, 2016 grand theft conviction, 2014 of vandalism and battery arrest. I forgot to put the total.
Okay, thank you. Ms. Allen?
Thank you, Your Honor. This young man in front of you has the majority of his criminal history out of California, and that includes probably 5 different DUI convictions, arrests for public intoxication, felony level drugs, felony convictions for robbery and theft, as well as obstruction. This is an incident specifically from the 6th. So yesterday, March the 6th, at about 3 in the morning, police were called to apartment 1717, 187 Maury Avenue Southwest. There they met with actually 4 individuals. The defendant in front of you, Mr. Terry, lives at the location with his sister, Mrs. Takia Muriel Spencer. His current girlfriend, last name Kouate, Kouate, reported that during the early morning hours, the defendant began playing music very loudly. She tried to get him to turn that music down. He went into the bathroom, turned it up louder. When she went into the bathroom and removed the speaker, she was trying to be mindful of the fact that other individuals lived in the home. He came out of the bathroom without any clothing on, yelling at her and approached her in an aggressive manner. She went to his sister, Mrs. Muriel Spencer, who is the owner of that location, because she was afraid. And at that point, Mrs. Muriel Spencer, who was sleeping on the couch, got up and spoke with her brother, who was observed to start repeatedly striking her in her face, causing bruising. That's the battery family violence. The defendant in front of you, his stepfather, Mr. Andre Peterson, also stepped in and was repeatedly struck by the defendant. Officers noted he didn't have any injuries. Muriel Spencer, Mrs. Muriel Spencer, fought back. So did Mr. Andre Peterson, and I'm guessing that's why the defendant in front of you has an injury to his hand he wants you to know about. So Mr. Andre Peterson is the victim of the simple battery. Girlfriend, last name Kouate, is the victim of the simple assault. He approached her aggressively, yelling at her, and she ran for help. Victim Takia Muriel Spencer is the victim of the battery family violence with bruising on her face, having to be removed and helped by others there at the location as a response to being assaulted by this gentleman. And unfortunately, Mrs. Muriel Spencer's juvenile child initials DL was present for all of this. We did speak to his stepfather, the defendant's stepfather, Mr. Peterson, and Mrs. Takia Muriel Spencer, who is his sister and the main victim here. His sister, who I believe has joined us on the Zoom, reported that she flew her brother out here from California to try to help him. He recently was in a rehabilitation facility. There's been a long history of abuse and violence, but also a drug problem. Her intention was to assist him out of good intentions, Your Honor, but unfortunately he has relapsed. She does not want any contact. He cannot return to the location, but he will need a one-time law enforcement escort. We're asking for a $4,000 surety. Not only is this defendant a risk to reoffend, but he's not a resident here, and he's a risk to flee. So this is our request for a $4,000 surety, no drugs, alcohol, or weapons, and to stay away from that location and have no contact with the victims in this case. Again, the location is apartment 1717 at 187 Maury Avenue Southwest. And if you could call for Mrs. Muriel Spencer or Mr. Peterson.
And it was 1717, correct? Is the unit number?
Yes, Your Honor.
All right, thank you. All right, first I'm sounding for Mr. Peterson. Mr. Peterson, if you're present and wish to make a statement, please turn on your camera, raise your right hand. Is that Mr. Peterson who just turned on the camera?
I don't know that.
I don't know either. Okay. Ms. Muriel Spencer, if you're present and wish to make a statement, please turn on the camera quickly.
I'm here.
All right, please. We can't see you. Please aim the camera away from, yes. Please raise your right hand. Do you swear or affirm testimony you give today be true to the best of your knowledge?
Yes.
All right, you put your hand down. What I'm most concerned with are concerns you have for your safety and desires for contact. If you want to tell us about the facts of what happened, let's hold that for another day. All right, today is just a bond hearing, and defendant is entitled to a bond. So what would you like to tell me?
Pretty much just a stay away order, and also requesting like rehab or rehabilitation, a mandated order for some type of drug rehab.
All right, I appreciate you coming to court and making that statement. Thank you. Mr. McLean?
Thank you, Your Honor. Kwame Terry is about 30, looking at his date of birth. I didn't do my math real quick, 43 or 44. And he has some college and works in the manufacturing field, Your Honor, and has skills in that area. We would, on those bases, he shouldn't have any problem at his age and skill level. He won't have any problem finding a different place to live. We would ask appropriate conditions on the bond. We realize there will probably be a stay away. We discussed that. And we asked the court to consider the lowest bond possible, including a signature bond, if indeed that is possible as well.
All right, thank you. Defendant is going to receive a $3,000 surety bond broken down as follows: 1,000 count 1, 1,000 count 2, and 500 on each remaining count. He's had no contact with any of the alleged victims in this case. Stay away from that location. He can return one time with law enforcement to get any items. Additionally, he's had no drugs, no alcohol, no weapons as a condition of that surety bond. Is there anything additional from state or defense?
Nothing.
All right, hearing none. Best of luck to you, sir. What do we have next?
This is number 10, Mr. Shig.
All right, Mr. Shiggs, your case is 25 CR 001181Y. You're charged with battery family violence in this case. Do you understand your rights?
Yes.
All right. Mr. Howard.
Let's see. This is fourth arrest. 2022 battery DV, 2 counts. A simple battery DV trespass. I'm not sure what the disposition was. 2018 hit and run NOLO. 2015 sale of marijuana.
Ms. Allen, please proceed.
Thank you. Those cases are all out of Gwinnett County. That battery family violence against his brother for repeatedly striking him in the head with a can, causing him to bleed from his ear. That's still open. He has a felony drug with intent to distribute out of 2015 in Gwinnett that he got a 2-year sentence on, Your Honor. This is an incident from yesterday, March the 6th. At about 1:15 a.m., police were called to 1185 Collier Road Northwest. The 911 call was made by the victim in this case. Sorry, one moment. The 911 call notes state that on an open line, she could be heard to be crying. There was a dispute in the background, and she reported that the defendant was trying to strangle her. On scene, police arrived and spoke to this young woman. I'll give you her correct name in a moment. She's here with us. She reported that the defendant demanded her car keys so that he could leave and go to the store. He became angry when she said no. He began making threats to her and being violent. He came close to her and then grabbed her by her neck and strangled her. Specifically, the warrant states he choked her with his hands on her throat, leaving bruises and red marks and scratches, and that they lived together at the location. The police documents note that while they were still on scene, the defendant was observed coming up in the elevator. The elevator doors opened, and once he saw police were present, the doors closed. He closed those doors and fled. He was apprehended nearby. The defendant did reach out to this young woman this morning or after the arrest. So in the early morning hours of yesterday, the 6th, through jail phone calls. And the very first phone call, the first thing this young woman says to him is that he needs to not do things like strangle her, and his violent behavior needs to stop. And she doesn't know what he was on, but this can never, ever, ever happen again. He blames her for being in jail and talks about how you're gonna, ruin my life basically by, helping the police or do this to me, because of course it's all her fault that he strangled her. When we did speak to the victim, Your Honor, she reported that she was never strangled. She didn't say she was strangled, and everything's okay, and she wants him to come home. Our position, Your Honor, is that she has been intimidated at this point and told what to say, which is also a felony, that this is a felony strangulation and should be upgraded. We're asking for a $3,000 surety, stay away from the victim as well as her home.
Absolutely
no
not.
contact, and no drugs, alcohol, or weapons while on bond. And of course, Mrs. Goolsby, her name is Chantel Goolsby, she's here. You're more than happy to speak with her.
Hi.
No, we will wait. One moment. You will not interrupt, Miss Allen. One question, Miss Allen. Can I have that address again?
Of course, it's 1185 Collier Road Northwest.
Your Honor, if you could put Ms. McLeod and South Annex in a breakout so that she can interview her client.
Oh, okay. Is it Miss McLeod? Are you there?
We interviewed before I logged in. She just did.
So she's good to go? Okay. Thank you so much. We
Thank
appreciate
you.
it. All right, Ms. Goolsby, please raise your right hand. Do you swear or affirm testimony you give today be true to the best of your knowledge and given under the penalty of perjury?
Yes.
Again, I'm only concerned with concerns for your safety and desires for contact. What would you like to tell me?
We were both drinking. Jason did not strangle me or choke me. We were in a little tussle, but there was no strangulation at all by any means. I've only talked to him once. We both do have a drinking problem, so that's what I'm referring to. We both need to stop.
What I'm telling you is please stick to what I've instructed you. The state is listening. Anything you say can be used against you as well, because I do have you under oath, okay?
Yes,
so
ma'am.
Please listen to my instructions carefully. I'm most concerned with if you have concerns for your safety and if you wish to have contact, please stick to that, but please continue, okay?
Okay. No, I do not have any concerns for my safety at all. Contact is fine. I don't have nothing on my neck, so.
All right.
In the jail call, the victim did tell the defendant that she's got marks and bruises on her neck because of him specifically.
I have nothing at all.
I mean, it's fine. The words that you use will just be used against you later.
All right. Thank you both for that. Mr. McLean, please proceed.
Thank you, Your Honor. Jason Shiggs is 29 years old. He's lived in Georgia all his life. He now has his address on Lanford Circuit in Lilburn. That's kind of near the tennis venue. There where the story ends. He is a sous chef for the last 5 or 6 years. Restaurant, which has 2 Atlanta locations, and is well. And he's very skilled at what he does there. We'd ask the court to consider a signature bond. And if that is not possible, we'd ask the court to consider a surety bond in the range of 1 to 2,000.
All right. Give me one second. Let's see if this just happened yesterday. Okay. I don't think there's been a sufficient cooling off period. So defendant is going to receive a $2,500 surety bond. He's to have no contact with the alleged victim, stay away from that location. He can return one time with a member of law enforcement to get any items should he need to do so. Additionally, he's to have no drugs, no alcohol, no weapons. He is going to the all-purpose calendar on the 20th, whereby contact and other aspects of this case can be revisited at this time. Is there anything additional from the state or from the defense?
No, Your Honor. Thank you.
All right. Best of luck to all parties concerned. The matter is now concluded. Who do we have next? Okay, there's a question at courtroom 2. Very briefly, what's the question?
I just wanted to say that, yes, we did get in an argument.
Do not, no. Anything you say is going to be used against you. Don't do that. I'm trying to help you, okay? It's to your advantage to not say anything else. Okay, do you have a question about the bond?
Yes, is it possible to have a signature bond? Because in the same situation, she has also came a few months ago and I showed up on court the way that she did. What?
Are you implicating the victim? Please stop talking. What's happening? I'm really trying to keep you from digging your own hole, okay?
Really?
If you have questions or concerns, please call your attorney. Please don't untalk your blessing, okay? Best of luck to you. I will not be converting it to a signature bond at this time. Oh, boy. All right. We have last position 1. And is there an announcement for position 11?
You should have been here yesterday, Your Honors.
I'm sure. Will we be taking position 11 today?
Worse than that.
Your Honor, no, he'll be a medical reset.
Position 11 is a medical reset. What about position 1? Will position 1 be brought?
That is South Annex.
All right, I'm ready for
Good afternoon, Your Honor.
Good afternoon. Is Mr. Cloud there?
Yes, I have 17-year-old Mr. Cloud.
All right, one point of question. I know this is first arrest, Mr. Howard, before we go through his rights. Are you able to take these type of charges if I think that's necessary?
I suppose.
I know there's some challenge. I just wanted to know what pretrial's current policy is regarding that. You suppose. Okay, we'll revisit that. All right, good afternoon, Mr. Cloud.
Good afternoon.
I'm Judge Melanie Williams, and your case today is 25 CR 00117-2F, in which you're charged with possession of a pistol or a revolver by someone under 18. You have an absolute right to remain silent. Anything you say can and will be used against you. You also have the right to counsel. Today, as you can see, I am conducting this hearing via video. That means I'm not there with you in person, and other members of the public may be able to log on and watch this. Do you understand your rights today and how I am conducting this hearing?
Yes.
All right, this is first arrest, so we will go straight to Ms. Tucker.
Yes, Judge. Apologies in advance. Amazon drove by. My dog is barking uncontrollably. Okay. The state is requesting a $5,000 signature bond through pretrial with a curfew, the requirement of a cosigner, and the condition to have no further contact with either of the individuals in the car. Those are Justin Butler and Kebron Robinson. The facts allege that a car was pulled over for a window tint violation. This defendant was sitting in the passenger seat. There was a strong odor of marijuana in the whole car. He was frisked for weapons and found a black Glock handgun in his waistband, As you heard, he is 17 years old. He did, after being Mirandized, he told the officers that he had found the handgun, but would not disclose where or when. Based on the lack of history, the state is willing to give a signature bond through pretrial if it is $5,000 and with all of those conditions as stated.
Okay. Um, I'm assuming you don't object to that signature by Ms. McLeod, but I would have other conditions in
I do
addition
not
to what.
object to the signature bond, Your Honor. My client is still in high school. He's in 11th grade at Benjamin E. Mays High School. I was able to speak with his dad, and his dad is willing to co-sign on the bond. I believe he may be logged in now.
Okay, so we have the name of the father for pretrial
Yes,
services.
it's Derek Cloud.
Can you put it in the chat because Derek has different spellings.
Yes.
Okay, defendant is going to receive a $10,000 signature bond through pretrial services at level 1. He's going to do 10 hours of community service. He is going to stay enrolled full-time in high school. He is also going to have a curfew that extends from 9 p.m. to 6 a.m. Is there
Eyes
any?
on Your Honor, Derek Cloud.
All right. Is there anything additional from the state of defense as it pertains to Mr. Cloud's case?
What did you say the curfew would be, Your Honor?
9 p.m. to 6 a.m.
I am presuming that should be okay for someone who's attending high school.
I
I
would
don't think they
assume
pick them
so.
up any earlier.
I don't think so. I don't think there's anywhere productive to be outside of those hours. Mr. Cloud, I am giving you a second chance here. I expect you to fully abide by all the requirements of this. These are very serious charges that you are facing. Do you understand me?
Yes, ma'am.
All right, and you need to get that community service done at a nonprofit organization, not a church, a daycare. It must be someone who can provide you with a letter, okay?
All right.
All right. I believe that concludes that case. Is there
Thank you,
anything?
Your Honor.
All right, take care. Stop that next. Bye-bye.
Thank you, Your Honor.
All right, I believe the entire calendar is now complete. Miss Lewis, will you please review it for me?
Your Honor, I would like if pretrial could tell Mr. Cloud, Derek Cloud, what he needs to do to get his son out. He's still on the zone.
I thought he bounced. Oh, he's on there. You got the link to send him?
I do not. If you would send it to me, please.
Send me your email address, please.
Oh, absolutely. I will put it in the chat now.
Thank
Okay, y'all ready to go over the counter? Can everybody hear me?
Yes.
you.
Okay.
Yeah, we can hear you.
The reset date for the SAP is going to be March the 20th. Position number 1, we're doing the add-on counter first. The add-on counter is a total of a $3,000 surety bond reset for SAP. Position number 2 is a total of a $1,500 surety bond reset for SAP. Going to the original counter, position number 1 is a $10,000 SOB through pretrial level 1. Reset further notice, co-signer be Father Derek Cloud. Position number 2 is a total of $1,000 surety bond reset for SAP. Position number 3, posted bond already. It was $1,000 surety bond, including the stay away condition on the bond. That case is going to be reset further notice. Position number 4 is a $1,000 surety bond reset for SAP. Position number 5 is a total of $1,500 split bond. It's $1,000 on the surety on the simple assault and a $500 SOB through the jail for disorderly conduct. That's reset for SAP 320. Position number 6 is a $4,000 SOB through pretrial level 2. Reset further notice. Position number 7 is a $1,000 surety bond reset for SAP 320. Position number 8 is a $1,000 surety bond reset for SAP 320. Position number 9 is a total of a $5,000 surety bond. We set for SAP 320. Position number 10 is a $2,500 surety bond. We set for SAP. And position number 11 is reset for the SEA counter for tomorrow, which is 3-8. Any questions or corrections?
Melissa, don't kick me off. I gotta get the email.
That was
Yes.
11, that's for tomorrow.
Yeah, unless they waive his
Oh, Miss
clearance.
McLeod, you weren't, I mean, not Miss McLeod, I'm so sorry. Mr. McLean, you weren't able to speak to 11 at all to get that waived, or is that possible that it might be waived for tomorrow? That's Mr.
No,
Wimbush.
Your Honor, we weren't able to. My
Okay.
email, I looked at the chat and see.
Okay, so he'll just be reset until he can be brought. All right. Well, thank you all.
Right.
It's been a pleasure being here this afternoon. The calendar is complete and we will be in recess until the SEA calendar tomorrow. I won't be here tomorrow, unfortunately. Take care, everyone, and enjoy the rest of your afternoon. Miss Lewis, I'll be waiting for the orders. I'll sit here until I
No, it's
receive them.
Katrina. I did it all today. Melissa.
I said,
That's what she said. She
Miss
said Miss Lewis.
I said Miss Lewis.
She said
Oh, I thought you
Miss
said
Lewis.
Melissa. I'm
I
sorry.
said Miss Lewis. I'll be waiting for the orders.
Okay, I'll get them over. And courtroom 2, I hope they got the answer to the bond amount. They asked what was the add-on number 2.
I responded.
Okay,
15 surety.
okay.
And Miss Lewis, I'll send you the victim names on Mr. Terry add-on number 1 if you need them.
All right, I'm gone. Take care,
Yeah.
everyone. Bye-bye.
Okay.
Thank you.
I
Mr.
think I
Howard, you
got them
still need
all.
me to stay on?
I sent it to
You
Yeah, you
good?
can still send
McLeod.
it
You
to
got
me.
it?
Yeah, I did.
Okay.
Yes, I'm going
Yeah.
to send it to Mr. Cloud now.
You about to send it to him? Okay.
Yes.
All right.
Miss Anna,
Yes.
I have Takia, Murray Spencer, Miss Kawida.
Right. I'm gonna send you an email with their names.
Okay, and I think Andrews,
Yeah, Andre Peterson.
Peterson, I'm sorry.
I'll shoot you an email real quick.
Okay, please do.
Yeah.
These
Thanks,
orders to the
everybody.
judge.
Have a nice
All right.
weekend.
Bye-bye, y'all. Take
Bye,
care.
Miss McLeod. You look beautiful as always.
Thank you. I will see you soon, I guess. Okay, I just emailed you the link. Okay? I can't hear you, but I'll call you.